Lauren is the Director of the Community Engagement with the Legal Aid Society of Eastern Virginia. As Director of Community Engagement, Ms. Mehosky's responsibilities include fundraising, pro bono coordination, public relations, marketing, and development of medical legal partnership with the Children's Hospital of the King's Daughters. In addition, Ms. Mehosky is an attorney with a full caseload of the organization's identification project cases. She obtains birth certificates and government-issued identification for the area's homeless and disadvantaged so they can obtain employment, housing, and other benefits. Ms. Mehosky has been with LASEV since 2006. Like other legal aid attorneys, Ms. Mehosky does not specialize in one area of the law and has worked in a variety of different areas, including housing law, family law, consumer law, and elder law. In her time with legal aid, she's handled over 1,800 cases. She received her BS in Spanish from Penn State University in 2001 and her JD from Regent here in 2005. She was admitted to the Virginia Bar in 2005 as well. And she's a member of the James Kent American Inn of Court and the Virginia Bar Association, the Norfolk and Portsmouth Bar Association, the Chesapeake Bar Association, and is a former member of the Newport News Bar Association from her time practicing here on the peninsula. She's also a PEO Chapter 10, and through that organization raises money for women's grants and scholarships. So, thank you.
Good morning. How is everyone this morning? We have a small group, so we can kind of make this a little less formal, so feel free to interact with me here. But I also know that it's early in the morning and maybe you don't want to, so my feelings won't be that hurt. All right, let me get set up here. So my program this morning is a little bit of a misnomer, and I'm sorry I've misled you a little bit. It's the ethics of representing and opposing the disabled, but you're going to get some more ethics credits this afternoon. So you're going to have lots of ethics today, but I'm doing this in a different way than most ethics programs in that we're going to look at the ethical rules from a completely different framework, okay? And this program today that you are attending is all about image. So you may say, well, what does working with people with disabilities have anything to do with my image as an attorney? And I don't know about you, but image for me is very important. And something that I strive to have as part of my image is compassion. And you heard my background in legal aid, so I work, with people in poverty law. You have to have a lot of compassion in that area. But even if you work in a large firm with a solo, in any area of the law, I think that you need, and we need as a profession, to have more compassion, not only for our own clients, but for opposing parties and really opposing counsel as well. I think it makes the process go a whole lot easier. Who's had cases where they've dealt with attorneys who are not compassionate and really have given you a lot of trouble? I mean, it just makes the whole situation a lot worse. So my focus today is compassion, but I wanted to tell you a little bit about dealing with people with disabilities. I have left some business cards up on the front table, so if anybody wants to get in contact with me or has any questions for me at a later point in time, please feel free to do so. I'm very accessible. You heard about my professional bio. I wanted to tell you a little bit about myself personally. Obviously, you can see my hands are a little bit different. I was born with a disability. It's not something that, it's kind of a fluke of what happened, and it's not something that I can pass on. So it's really kind of interesting, and I'm extra lucky in that it's both of my hands, not just one hand. So essentially, when I was in my mom's womb, my hands went up against the walls, and when you wrap a rubber band around your fingers and they turn purple, well, that's sort of what happened, and I wasn't able to develop. So I had, from when I was 8 months old to 8 years old, I had 13 surgeries on my hands. I had a doctor, I'm from New Jersey, don't hold that against me. I had a doctor in Washington, D.C. who did all the surgeries and took bones from my toes, tendons from my legs. So that's sort of my background, and honestly, my passion for working with people with disabilities really didn't start until I started working at Legal Aid. At Legal Aid, we see a lot of people with a lot of different types of disabilities, and unfortunately, people with disabilities tend to have more prevalence of poverty in their lives. They lack access to education, so we tend to see people with disabilities a lot more in legal aid. So I want to talk about who's disabled, because, obviously I am, you can see it, but there's a lot of disabilities out there that you just can't see. So I did some research into this, and I'm not going to read directly from my outline, but I'm going to be pretty close to it, but I'll try to make it interesting for everyone. But the World Health Organization says that disabilities is an umbrella term. It's covering impairments, activity limitations, and participation restrictions. And so impairments, there's lots of terms, and we as lawyers love our terms and our definitions, and it really helps us wrap our heads around what we're trying to analyze. So impairment is defined as a problem in body function or structure. An activity limitation is a difficulty encountered by an individual executing a task or action, while participation restriction is a problem experienced by an individual in involvement in life situations. So those are all pretty straightforward terms. I think we all can wrap our heads around those. But that really kind of doesn't answer the question, does it? What is a disability? So a disability is really a complex phenomenon, and it really has a lot of different definitions. And as lawyers, we think about disability, legal disabilities as well, so that just sort of adds on to the complexities of all of this. But really, it's this interaction between a person's body and society. So even though my hands look different, I don't act different, and therefore society may not treat me different. So am I disabled? I don't know. It's really something to kind of think about. Let's talk about some types of disabilities. Now, I want to give a disclaimer here. Again, it's another lawyer thing that we love to do. I have a list here of different types of disabilities, and there's a lot of different definitions that can be associated with each one of these. And there's a lot of different medical terminology, and so you can see I'm going down this road I don't want to go down very far. So if I state a definition and you feel like it's not something that you knew or doesn't comport with DSM or things like that, this is just really to serve as a broad overview for you. So that's my disclaimer. All right, so we have physical disabilities. Obviously, we all know what that's going to mean. It's going to be something you can see, something that has to do with something sort of, and I don't want to start getting into medical descriptions, but you know what I mean. We have different sensory disabilities, visual impairments, hearing impairments. We have olfactory and gustatory impairments, and olfactory is going to be a loss of your sense of smell, and gustatory, and I hope I'm pronouncing that right, is a loss of taste. We have somatosensory impairments, which those are impairments that affect one's ability to effectively and accurately process input received from sensory receptors in the skin. So these people are unable to potentially feel light touch, localize touch, discriminate temperature, identify an object through touch, discriminate sharpness, or ability to feel pain. So that's going to be your somatosensory impairments. You also have, within sensory disabilities, balance disorders. We have also intellectual disabilities, which according to the research I did, according to the National Dissemination Center for Children with Disabilities, intellectual disabilities are actually the most common disability. In the United States, there are 6.5 million people with intellectual disabilities. Intellectual disabilities are also known as cognitive disabilities or mental retardation. And so these are certain limitations in mental functioning and in skills, such as communicating, taking care of oneself, or social skills. And it causes the person to develop more slowly than a typical child. There's also mental health and emotional disabilities, developmental disabilities, which is a little bit more of an umbrella term just because it's defined as lifelong disabilities attributable to mental and physical impairments manifested prior to age 18. So you could have a developmental disability and then it sort of change into another type of disability after you turn 18. One thing I also want to point out, and I mentioned this before, the last column or the last part are non-visible disabilities. And some of the ones I've already stated obviously can be non-visible. So, as attorneys, you need to be really mindful of what your clients might be suffering from. But the last are interesting, the non-visible disabilities, and they say that would be chronic disorders like diabetes, sickle cell, things like that. Those are considered disabilities as well. So again, I'm probably not helping you understand the whole concept of disabilities, but it's probably not something that we can define. We just need to sort of have a greater understanding of it. Some more terminology, impairment, disability, and handicap. And I think that we all have sort of preconceived ideas about what these terms are all about. And I want to caution you at this point to, again, be mindful of these terms and how you're using them, and when you're dealing with clients or opposing parties, how you're using them. Unfortunately, I think, though, that you're going to not find a common theme, I guess I want to say it, as to how people feel about this. You might find someone who gets very upset if you call them handicapped. You might meet someone who's fine with being considered handicapped. Again, it's being mindful of these terms and being mindful of your particular clients. But impairments, a deviation from normal is what they're saying is an impairment. Not being able to make a muscle move or not being able to control an unwanted movement is sometimes considered an impairment. I know that for me, this is kind of personal to myself, but the term normal is kind of annoys me. So that might be something to consider when you're talking about clients, what's normal and what's not normal. Something that my mom told me when I was young, and maybe this turned me into a cynical, jaded adult, but everyone has something wrong with them in some way, shape, or form. No one is perfect. And so for me, the concept of normalcy is kind of annoying. So that's something just for you to be mindful. This terminology of disability is from Cerebral Palsy, A Guide from Care. So they define disability as a restriction in the ability to perform a normal activity of daily living, which someone of the same age is able to perform. So a 3-year-old child who can't walk has a disability because a 3-year-old can use, a typical, I'm not going to use the normal word, typical 3-year-old would be able to walk. Handicap is the term used to describe a child or adult because of the disability who's unable to achieve a normal, there's that word again, role in society commiserate with his age and socio-cultural milieu. And there's an example in here a 16-year-old who can't prepare his own meal or toileting or hygiene needs is going to be considered handicapped. Here's the tongue twister for the morning. All disabled people are impaired, and all handicapped people are disabled. But a person can be impaired and not necessarily disabled, and a person can be disabled without being handicapped. If you can tell me that or write that down, you win the prize for the day. So, but it's true. I mean, if you kind of pull it apart, it sort of makes sense, but that's your tongue twister for the morning. So, the American Psychological Association Style Guide states that when identifying a person with an impairment, the person's name or pronoun should come first, and descriptions of the impairment or disability should be used so that the impairment is identified but is not modifying the person. So here's another place where we just need to be mindful when you're dealing with clients and opposing parties about how to actually refer to this person. So improper examples are borderline, a blind person, or an autistic boy. And so they say the more acceptable terminology includes a woman with Down syndrome or a man who has schizophrenia. But again, you may have clients who may not be terribly sensitive to that. So you want to keep that in mind. And it also states that a person's adaptive equipment should be described functionally as something that assists a person, not as something that limits a person. So a woman who uses a wheelchair is better than a woman in or confined to a wheelchair. So we can see how the subtle differences in that terminology really affect how this person is going to be perceived. So, and I'm going really fast. Any questions at this point? No? I want to point out at this point, too. Well, let me go. I have some other things. Good. That's good. Before I go on to the actual ethical things. Okay. So the World Health Organization, obviously they are keeping tabs on different medical issues throughout the world, not just through the United States, but according to the World Health Organization, over 1 billion people, or about 15% of the world's population, have some form of disability. Honestly, I think that's a little bit low. I would think it would be even higher. And they say that between 110 million and 190 million adults have significant difficulties in functioning. Rates of disability are increasing due to population aging and increases in chronic health conditions, among other causes. So this is something to think about too. You know, people who are aging are going to be considered disabled in some way because of the aging process. So that's something to think about in dealing with your older clients as well. People with disabilities have less access to healthcare services and therefore experience unmet healthcare needs. And I'm not going to go into sort of the politics of that, but just think about that. So how are the lives of people with disabilities affected? There's tape here, sorry. All right, so these are some more things to think about. So you might know that your client has, let's say, a mental health issue like schizophrenia, okay? But in knowing and thinking about this, your client may actually have some more health issues. For example, people with disabilities often face an increase in what they consider comorbid conditions, and that's conditions that are in addition to and sometimes are unrelated to primary health conditions. For example, the World Health Association states that people with diabetes, people with schizophrenia are more likely to have diabetes than someone who does not have schizophrenia. So it's something to think about that, you may know about issue A and disability A, but the client may have other issues that you don't know about as well that you need to be sensitive to. That's also as far as secondary conditions, so those would be related to the primary health conditions and are usually more predictable and therefore preventable. But as I stated, this client may have issues in accessing health care, so again, some things to be sensitive. So examples are osteoporosis and pain, or ulcers and urinary tract infections. So, they're relatable, but they're all, an additional issue that the client is going to be facing. Age-related conditions. So, people with disabilities usually begin to have conditions because of age that come on a little bit sooner. So something that I know, I have a friend who has shorter arms, so that person has to move differently, and the spine and the back and shoulder muscles were not created for that. So this person is experiencing age-related issues because of the way that person has to move. So that's another thing. Engaging in health risk behaviors. Some studies, according to the World Health Organization, say that people with disabilities have higher rates of risky behaviors, such as smoking, poor diet, and physical inactivity. And for, obviously for physical disabilities, that makes sense because of their, physical limitations, but something to keep in mind. Higher rates of premature death, mortality rates with people with disabilities sort of vary depending on the health condition, but according to the World Health Organization, and under an investigation in the UK found that people with mental health disorders and intellectual impairments had a lower life expectancy. And we did talk about barriers to healthcare. That's another way that the lives of people with disabilities are affected. So I just want to point out, and I think this is obvious, but just something to put out there, people with disabilities are obviously very, very diverse. They differ in gender, age, socioeconomic status, sexuality, ethnicity, and cultural heritage. And each person has his or her personal preferences and responses that we talked about. So again, you don't need to kind of rush into your office and be really PC and think you're going to use certain terms because that person that you're talking to may not want those terms to be used. But if you're just aware of some of these issues, I think I've won for the day and I've imparted some wisdom. We talked about health conditions are visible or invisible. They can also be temporary or long-term. They can be static, episodic, or degenerating. They can be painful or inconsequential. So you might have someone who looks perfectly fine but is in a whole lot of pain. Or you may have someone who, like me, maybe looks like I'm in pain, but I'm really not. So you just have a lot of differences there. So again, I keep going to the World Health Organization because they seem to be really legit. So they put out a report on disabilities. It's the World Report on Disability. You can look it up online if you search with the World Health Organization. It's pretty interesting. There are a lot of obviously global health issues which make things a little bit different. Than sort of within the confines of your own offices. But it's interesting to kind of look at how disabilities and people with disabilities are treated in other countries. But the foreword, I really like there's a foreword written by Professor Stephen Hawking. I think that we're probably all familiar with him. He has a motor neuron disease, and he has severe limitations in communication and physically. But I think, as we all know, I don't know who has read any of his books. I have. They're incredibly complicated, but he's a really good example of someone who really never saw his disability as a limitation. And he even says in his own words that disability need not be an obstacle to success. And I think that's another thing. I keep saying, you need to think about this, you need to think about this, but this is really important when dealing with people with disabilities, is that just because they have a disability doesn't mean that they can't be successful and happy. So he says that, and then he says, he talks about his own situation and that he was lucky. He's able to, his success in the field of theoretical physics enabled him to have access to good health care and to have he says that he had a productive employment and personal fulfillment. So that was something that was good for him. But he says that, in fact, we have a moral duty to remove, and I'll talk about the ethical duty, to remove the barriers to participation and to invest sufficient funding and expertise to unlock the vast potential of people with disabilities. Governments throughout the world can no longer overlook the hundreds of millions of people with disabilities who are denied access to health, rehabilitation, support, education, and employment. And I like this, and never get the chance to shine. And that's what I really want to be the takeaway point, is that your clients and opposing parties want that voice. They want that ability to shine in their lives. And you can help them do that. In the preface, Dr. Margaret Chan, who's the Director General of the World Health Organization, and this is, again, I'm kind of repeating some of this stuff, but if I repeat it enough, maybe everyone will remember. Across the world, people with disabilities have poorer health outcomes, lower education achievements, less economic participation, and higher rates of poverty than people without disabilities. This is partly because people with disabilities experience barriers in that's my New Jersey accent, barriers in accessing services that many of us have long taken for granted, including health, education, employment, and transport, as well as information. These difficulties are exacerbated in less advantaged communities. To achieve the long-lasting, vastly better development prospects that lie at the heart of the 2015 Millennium Development Goals and beyond, we must empower people living with disabilities and remove the barriers which prevent them participating in their communities, getting a quality education, finding decent work, and having their voices heard. And that is a good segue into us as lawyers. I mean, that's our job, is to give people a voice and to give our clients adequate and competent representation. So, what are our responsibilities then? So, and this again sort of segues into why I chose this topic. I think that we as lawyers, we want to do the best that we can, but we also have a lot of pressures on us. We have pressures for time, we have pressures for billable hours, we have pressures to all of our clients. And I think sometimes, whether we maybe want to or not, when we have somebody maybe with a disability who comes into our office and might need some special accommodation, you get this sort of like, I don't want to spend that extra time. I don't know how to do relay. I don't know sign language. I don't know how to translate these pleadings into Braille. You just get this sort of sinking feeling. And I think that we need to step away from that and just remember who these people are and that they deserve the same level of representation that anyone else does. So just to kind of remind you, well, before I do that, I want to tell you about the ethics hotline, and I think you're going to be told a little bit more about this today, but I think it's really important to point out that the State Bar does have an ethics hotline. It's a confidential consultation, and for members of the bar, you can ask questions about ethics and also about the unauthorized practice of law. Because when we get into this, we're going to talk about some of these issues, and you'll see that there's maybe not with ethical questions and dilemmas, sometimes there's not, I don't want to make a blanket statement, but sometimes there's not a bright line rule and what I should do. You should do this, not this. It's a lot of times there's a lot of gray areas. So please feel free to take advantage of the ethics hotline, and you can email questions through the vsb.org website as well if you don't want to pick up the phone. All right, so if we jump to the preamble to the rules, a lawyer is really performing various functions, and we all know this. We're advisors, we're advocates, we're negotiators, we're intermediaries, we're third-party neutrals, and we're evaluators. And I'm not going to go through these, you can read them, but we wear a lot of different hats. And so I want us to think about those different roles when we're talking about the disabled client or the disabled opposing party. So again, we're going to talk about opposing self-represented and disabled clients and then representing them. All right, opposing them. And I think that we want to think about this is not just rules and concepts and aspirations just when dealing with disabled people, it's when dealing with everyone. But obviously, like I said, we're looking through the framework of the people with disabilities. But I also want to say that we want to treat people with disabilities differently. You know what I'm saying? We want to treat everyone the same. We want to treat everyone as fair as we can. And that takes us to Rule 3.4, fairness to opposing party and counsel. Specifically, I want to point out in comment 7 that the duty of a lawyer to represent a client with zeal does not militate against his concurrent obligation to treat with consideration all persons involved in the legal process and to avoid the infliction of needless harm. So, I know that there's, again, I talked about those pressures, and sometimes there's the pressures from our clients to really get emotional about a case and to really try to make a case more difficult than it needs to be. But you need to keep in mind your ethical obligation to keep things fair and to not make the process more difficult than it needs to be. Dealing with unrepresented persons, Rule 4.3. Because you're going to find, you heard me say several times that the people with disabilities are going to likely be of a lower socioeconomic class. So unfortunately at legal aid, we can't help everyone. So you're going to, there's a higher likelihood that someone that's pro se is going to have a disability. So when you're dealing with an unrepresented person, you cannot state or imply that you're disinterested. When you know or reasonably know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. And subsection B, which is the one that I think we all know and deal with more regularly, is that a lawyer shall not give advice to a person who is not represented by a lawyer other than the advice to secure counsel, if the interests of such person are or have a responsibility of being in conflict with the interests of the client. So, I mean, who would maybe be tempted, say you have an opposing party who maybe seems like he or she has an intellectual disability. High functioning, this person, is not legally incapacitated. Sorry. Are you going to feel like maybe because you know that person has a lower level of understanding, are you going to feel sort of the temptation in giving that person advice? Because what's the harm, right? I mean, what do you guys think? Do you think that that's something that you'd be maybe tempted to do if you saw a person who you perceive to be maybe a little bit more vulnerable than sort of someone else? But you can't, okay? So keep that in mind. I won't force you to participate. So really, the only advice you can give to an unrepresented person is to obtain counsel, okay? All right, I'm watching the time. Representing disabled clients. All right. A lawyer, Rule 1.2, in your scope of representation, a lawyer, subsection A, a lawyer shall abide by a client's decisions concerning the objectives of representation subject to paragraphs B, C, and D, and shall consult with the client as to the means by which they are to be pursued. And this is, I'm going to sort of pose that same question. If your client has maybe a bit of a diminished capacity for understanding, and let's face it, I mean, with some of our cases, we have very complex legal issues, and even the most intelligent of our clients maybe are not going to understand the full implications of the case. So if you have a client with some sort of diminished capacity, what are you going to do as an attorney? Are you going to take over, or are you going to let the client be the co-pilot in the case? And ethically, you need to have the client be the co-pilot in the case as far as what the rules state that the client has the right of decisions to make. But I want to say, we're going to go over this. Keep in mind that Rule 1.14 with a client with an impairment is going to factor in as well. So comment 1 to Rule 1.2 states that the client has ultimate authority to determine the purposes to be served by legal representation within the limits opposed by the law and the lawyer's professional obligations. All right. Comment 4. And I just say this, but it actually is in the comments. In a case in which the client appears to be suffering mental disability, the lawyer's duty to abide by the client's decisions is to be guided by reference to Rule 1.14, and that's what I stated as client with an impairment. I want to point out that the rules, the ethical rules, they're not in full in the outline, but if you go to vsb.org, you can find the full rules. All right, diligence. This is a big one. So comment 1 states that a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer, and may take whatever lawful and ethical measures are required to vindicate a client's cause or endeavor. So here's what we were talking about earlier, that you have a client that comes in who may have a hearing impairment, and you need to be able to communicate with that client in an effective way to prepare a case. But it's kind of a pain in the butt to use relay, but you need to keep going on. I mean, the rules say that it doesn't matter if you personally think that using relay is a little bit of a pain. you have to work through that personal inconvenience to be able to represent the client. So that's where I really wanted to point out as far as that particular rule. And I did put in there that disabled clients deserve the same respect and work product as anyone else. And somebody told me that as far as all of our clients at Legal Aid, and that's how we treat them, is that, you know, it doesn't matter how much money they have, they deserve the same level of representation that they would receive at the top law firm. So again, we need to carry that over to disabled clients too. Rule 1.4. Excuse me. Okay, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make an informed decisions regarding the representation. So what happens, again, when your client has a little bit of diminished capacity, how do you do that? And there's not an easy answer to it, but the rules do state in comment 5 that the client should have sufficient information to participate intelligently in decisions concerning the objectives of the representation and the means by which they are to be pursued to the extent the client is willing and able to do so. When you write letters to clients, and I am going to force a little participation right now, when you write letters to clients, what grade level are you writing the letters to at? What would you say? Throw out numbers. 3rd grade, okay. What about everybody else? High school, okay. High school, okay. The average American really can only understand at a 5th grade level. And that's the average American. So when you have somebody who has, you know, some sort of disability, that is going to be even lower. So that's something that you've got to, again, it's pressures and time versus competent representation. You know, if you write a letter, you may have to take that extra time to make sure and read it and say, okay, if I didn't know anything about this and I didn't understand X, Y, and Z, could I understand this letter? Because you're not competently representing your clients if they have no idea what's happening. So that's another thing to keep in mind. Just trying to see if there's anything else I wanted to point out in that comment. Comment 6 states that ordinarily the information to be provided is that appropriate for a client who is a comprehending and responsible adult. But again, I just stated that about the average, and don't quote me on that, but I believe it's 5th grade. However, fully informing the client according to this standard may be impracticable. For example, where the client is a child or suffers from mental disability. So it seems to me like in this part, they're saying that you might not be able to do it, but you still need to provide competent representation. So for me, my interpretation is that maybe they're letting you off the hook a little bit in that comment, but you still need to know, your client needs to know what's going on. All right, here's the big one. This is Rule 1.14, client with impairment. And I'm actually going to kind of read the first 3 subsections, and I'm going to emphasize a few words here. So when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or some other reason, the lawyer shall, so is that a may or a shall? So that's a shall, we have to do this, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. So we have to treat them like everyone else, as far as reasonably possible, okay? So there's going to be times where you as a lawyer, you know, you're going to come out of this program and you're going to say, all right, I now understand that there are people out there with different limitations. I need to be more sensitive to this, so I'm going to just treat them like anyone else. Well, you know, there's not going to be every time that you can do that. So I want you to take the message home, but know that, again, there's always going to be that exception to the rule. B, when the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action. And that's one of our favorite ambiguous terms. What does that mean? But that includes consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. Okay, so let's say you have a client who you are defending in a certain civil action, okay? Let's say this client's capacity is so diminished that the client does not understand the consequences of potentially losing this action, okay? And let's say that this client is potentially going to be homeless from this action, okay? If you're the attorney, what do? Well, first of all, you're going to represent that client the best you can. Are there any defenses to this action? Maybe there's not. So then what do? This person is potentially going to be a danger to himself or herself if this person is homeless because of the mental impairments. So what do? I mean, this this rule says that you can take reasonably necessary protective action. So what does that mean as far as the law goes? I mean, does that mean you get a guardian ad litem, and that guardian ad litem can maybe use his or her powers to help the client, maybe with some sort of involuntary commitment or something like that? You've got to think a little bit outside the box, and that's, again, where it comes into more about thinking about the client as a person rather than just another file or another case. And the rules of professional responsibility do allow for that. Part C, information relating to the representation of a client with diminished capacity is protected by Rule 1.6, which are our confidentiality rules. When taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 16A to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. So if you felt a little squirmy with me talking about what we would do for that client I just talked about, this helps you know that you can take steps. You know, the confidentiality rules are not final and set in stone when it comes to clients who are facing issues like this. So you can take, when you need to take the reasonably necessary protective action, you can reveal certain information that would help and assist the client. And what they say, protect the client's interests. So in the comments, in comment 1, so I want to talk about that normal client relationship. So the comments state that that's based on the assumption that the client, when properly advised and assisted, is capable of making decisions about important matters. When the client is a minor or suffers from diminished mental capacity, maintaining the ordinary lawyer-client relationship may not be possible in all respects, and we kind of talked about that. In particular, an incapacitated person may have no power to make legally binding decisions. Well, I hope we all know that. That's pretty basic stuff. But nevertheless, a client with diminished capacities often has the ability to understand, deliberate upon, and reach conclusions about matters affecting the client's own well-being. You'd be really surprised if you do work with people with disabilities that, you know, they might have, you know, you may think that they don't know what's going on, but they do, and a lot of times they do know what they want. Now, well, is that in their own best interest? We won't get into that. Comment 2, this one's really important. The fact that a client suffers a disability does not diminish the lawyer's obligation to treat the client with attention and respect. I think you've heard me say that sort of ad nauseum at this point. If the person has no guardian or legal representative, the lawyer must often act as the de facto guardian. Okay, does that make anyone uncomfortable? That kind of makes me feel a little uncomfortable. There's a lot to that. Even if the person does have a legal representative, the lawyer should, as far as possible, accord the represented person the status of client, particularly in maintaining communication. All right, so what happens when you have a client with some sort of diminished capacity or issue, and you need to talk to somebody about it? You need to get more information. You need that to help your case. What do? Well, comment 8 has about disclosure of the client's conditions. So court rules generally provide that minors or persons suffering mental disability shall be represented by a guardian or next friend if they do not have a guardian. However, disclosure of the client's disability can adversely affect the client's interests. For example, raising the question of disability could, in some circumstances, lead to proceedings for involuntary commitment. The lawyer's position in such cases is an unavoidably difficult one. The lawyer may seek guidance from an appropriate diagnostician. So again, the rules sort of don't help delineate this area that's a little bit gray for us. So what do you think that we do in this type of case? I mean, so you don't want to adversely affect your client's interests, but you need to know what to do. So this is where I'd say that working with medical professionals and healthcare professionals is going to be important in that type of situation. But I don't have the exact answer for you. All right, and our last rule that we're going to talk about is about Rule 2.1, Advisor. So comment 2 says that advice couched in narrowly legal terms may be of little value to a client, especially where practical considerations such as costs or effects on other people are predominant. So this is where we talked about our letters and our other potential communications to clients that need to be something that the clients can understand. And that's set out in this rule. And the last one is comment 3. So people might come to you and ask you for that purely technical advice, and you might be tempted to really sort of give it to them in a very complex and technical way. But you have to keep in mind that if this client, what the comment says, is inexperienced in legal matters, you still have to bring it to their level at that point, okay? That's all the rules I had. I want to point out, if this topic is interesting to you, there's this really good book that came out just a little bit ago, and it's called Far from the Tree, and it's written by Andrew Solomon. And he wrote another book called The Noonday Demon about depression. And as you can see, this is pretty thick and would hurt someone if you chucked it at them. But it's all different chapters about different, I don't want to say disabilities because it includes some other things as well, but the subtitle is called Parents, Children, and the Search for Identity. And so Solomon is proposing that diversity is sort of what unites us all. And you might have read articles about families who have children with Down syndrome. Often, while it's a big shock at first, they often lead more fulfilling and happy lives in the long run. And that's kind of the supposition of this book. So he writes about families coping with deafness, dwarfism, Down syndrome, autism, schizophrenia, multiple severe disabilities, with children who are prodigies. So that's why I say it's not necessarily a disability, although, I don't know, I guess you can make an argument that, children who are prodigies potentially have some sort of, they're not normal. About children who are conceived in rape, who become criminals, who are transgender. And so while each of these characteristics is potentially isolating, the experience of difference within families is universal, as are the triumphs of love Solomon documents in every chapter. And he talks that all parenting, and I'm just reading this from the jacket, I hope that's okay. So all parenting turns on a crucial question. So to what extent parents should accept their children for who they are, and to what extent they should develop them or to become their best selves. And so he did he did all these interviews with people, and they said that he sort of created this book from 40,000 pages of interviews. So it's a little heavy stuff, maybe not for right before you go to bed, but it's really interesting, and even though it's written from the perspective of parents to children, I think it's something that you can just take away in your dealings with people in everyday life, and just understanding and sort of stripping away some of these negative connotations with disability. I know that I've lived a really happy life. And, I had a doctor when I was about 4 who said I probably wouldn't be able to like feed myself or tie my shoes or anything like that. And I just kind of thumbed my nose at that and said, okay, well, I'll show you otherwise. And, the potential in all of us is there. And so I just want us as lawyers to see that potential and to give that voice to people. So thank you very much. Does anybody have questions? Yeah, Leonard. I saw your hand go up. Not an area I know too well about, so I don't think I can answer your question. I didn't do any sort of research on that, so I apologize. But I can get you an answer if you want. Grab one of my cards. Yeah, okay. I do apologize. I'm getting into special ed law a little bit more with our work that we're doing with CHKD. So we're actually working with the clinic up in William & Mary. So they're going to help us out with that, the Pay Lake Clinic, if any of you are familiar with that. Any other questions? I think there was one on this side. Yeah. Mm-hmm. 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 It's a hard line to draw, and I think that I'm going to make and it's not a cop-out answer, but it's our favorite answer as lawyers. It depends. I mean, you're going to get some guardians who are going to take a very strict and narrow view of their role as guardian, but I don't, and just say this course of action is going to be in my client's best interest or it's not. But you might have some that don't want to take that next step and really make that recommendation that you can follow as an attorney. I think it's a really delicate situation that you may even want to have other people involved if there's family members or other social workers or anything like that might be involved to really sort of help, especially maybe if you're in front of a judge and you have to present this to the judge so that the judge knows that there's sort of a team of people who are sort of behind this situation. So it's a really hard line to draw. But I think that you have to balance the rule of your client being able to make those decisions on settlement versus when they have an impairment. So I think it's really just where it falls sort of in your gut as far as which way you should go with it. Thanks. All right. Well, thank you. Oh, one more question. Mm-hmm. Yeah, I don't know if I do know the question was about the DSM-5 and the big changes that are coming. I don't know how. I haven't seen anything yet as far as how that's going to implicate, let's say, Social Security regulations in them making determinations of disability. I haven't heard about that quite yet. It's going to be very interesting though to see sort of what does happen legally with it, and sort of my focus is more on what we as a society, how that's going to trickle into society and how we perceive people with disabilities and what's going to be included as disabilities. So I think for me that's more of my interest. But to answer your question, I haven't really heard how it's going to trickle in legally at this point. All right, thank you very, very much. We hit 50 minutes, so congrats. You survived your first hour.